Okay, so we're going to do service agreement. Service agreement is the subject matter of agreement is service. So some sort of labor. So there will be a company that commissions the service. So a commissioning company, that will be one party to the agreement, and the other party will be a service provider. Now, what are the things that you have to check? What are the major points of a service agreement? First, the scope of a service. Obvious. So are you building a room, or building a whole building, or are you building a whole city, right? Now, there are times that it's not set. It's not set in the beginning what the scope will be. When it's not certain from the beginning what the scope will be, you enter into master service agreement. Under master service agreement, the two parties, the commissioning company and service provider, agree on the terms that will apply if there is a work order from the commissioning company. Okay. So they agree in advance what these permanent terms and conditions will be. The permanent terms and conditions upon which the future services of whatever scope that they may agree on are conducted. So that way they agree on what the terms will be first and then decide on the scope later. Now, what's most controversial in the service agreement is, guess, the standard of evaluating services. Okay. When will you decide that the service has been completed? Right? Under what condition are the services deemed completed? Now, it's really difficult because if you already know what a good result is, right? If you already know what a good result is, then you probably did not need to hire somebody else to do it. Okay? You hire someone else, you hire a service provider because you don't know the result, you don't know the means to get to the result. Okay. So, I mean, if you, yes, you can have like the most strict way of deciding on the standard will be just, add specification, right? So, and the result will be, 3 by 4 by 6, right? And then, if the specification is not met, the service is not completed. That can be one way of determining the standard of completion. But if you're going to do that, why do you enter into a service agreement? You just enter into a buy and sell agreement. You just enter into purchase agreement to get what you want. Right? You don't need to go into a service agreement. You go into service agreement because you don't know what the final product you desire is. Okay. Now, there are times that I mean, there are some specifications. There are some specifications that you can decide in advance. So, for instance, write a software that finishes a transaction under, I don't know, 200 milliseconds or something. Okay, certain transaction. That is also possible, but there must be different ways of doing it, right? So under 200 million seconds. There must be different ways of achieving this. Okay. So this is present. This is future, and there will be different ways of achieving the desired result, and you would not know which of this is the most sensible way of achieving the desired spec. So what ends up happening is you either leave it to the industry standard, okay, or you leave it to the discretion of the commissioning company. Okay. Now, the more specification you put in, the more you will feel like entering into a purchase agreement. But a lot of times, you either don't know the result or you don't know how to get to the result. That's why you enter into a service agreement. The best example is attorney service agreement. Okay. Yes, you want to win, but you know that lawyers will not work for you if you say, hey, we'll pay you only when you win, right? There is no success fee only agreement. There is no such thing as a 성공보수만. There is no such thing as a success fee only lawyer service agreement. You need to put some money up. But you don't know what those services should be that you don't know what services you should be getting for the money that you put up, right? That's why you enter into a service agreement, and there you have to resort to this abstract standard, such thing as industry standard, or leave it to the discretion of the commissioning company. Okay. All right. So standard of completion is one controversial point that you have to negotiate. The other is deadline, by when the full service will be rendered. The third is service fee. Will you be paid for time you spend, or will you be paid for the work you accomplished? Okay. I mean, think of yourself as a lawyer, and there are lawyers who get paid by the hour, and there are lawyers who get paid for the work. And a lot of times, there can be a combination of the two. Okay? So time charge up to a certain point, right, for finishing a certain work. Okay? So you are being paid for the work, but toward the completion, you are paid by the hour. And when you hit the maximum, you are not paid anything beyond that maximum. Okay. The next point is expenses for tools and materials. Who are paying for the expenses? Who are paying for the tools and materials? Okay. And also, if it says co-service instead of co-service, it should Probably the better term will be joint service agreement. Okay. Joint service or joint production agreement. The commissioning company also participates in providing services. So they are doing something together. Okay. It's not just one-way agreement. They are both rendering services to each other to create something together. That's a joint production agreement or joint service agreement. Here, who does what, that should be made clear. Okay. Is company A developing software while company B developing hardware? Okay, then it should go into the contract. Okay. Now, there are special types of service agreements that require special attention. That is development agreement. Okay. What is development agreement? The service required is supposed to leave an intellectual property behind. Then we call it development agreement. Okay. What are the forms of what are the IPs? What are the intellectual properties that we talked about before? Patent, copyright, trademark, know-how even, right? Even know-how is trademark. I mean intellectual property. If there are lasting intellectual property at the completion of the service, then you are entering into a development agreement. And if it's a development agreement, you need an extra provision about who owns the results of the development services. Who owns? Now, one extreme will be work for hire. Okay. So if somebody gives me $1 million for developing a certain software and say, hey, you are working for hire. Okay. You are writing that software as work for hire. If the contract says so, okay, if the contract says I'm developing the software as work for hire, then at the completion, the software I made, I don't have copyright to that software. It's the commissioning party that has the copyright. Okay. Now, the work for hire situation does not arise just from a contract that says work for hire. It also can arise from an employment relationship. Okay. So if you write if you're a developer working for Microsoft and have written some code, all of that belongs to Microsoft, not you. Okay. Now, for that relationship, for that you don't need a contract, right? Because the employment relationship is already there. But if your company is if your company is a developing company, if your company is a developer and is developing some software for another bigger company, you have to watch carefully out for work for hire provision. Because if there is one, then your client will lose all the rights to the codes that they've built, for several months. Okay. All right. Now, of course, if there is no work for hire, what's the result? Then the developer has it all. Because under copyright law, the author, by default, has the copyright. If there is no contract that says otherwise, right? If there is no contract to the contrary, then the author owns the right. Okay. Now, there are times that the developer has underlying intellectual property. What I mean by is that, for instance, let's say the service that you are providing is developing a shooting a film, okay, motion picture, right? And let's say you already have a scenario before entering into an agreement with another company, okay? Right? For instance, film producers, they enter into production service agreements with film distributors. Film distributors, they put up the money. Okay, they put up the money for developing the film, and who owns the rights to the film, the completed film? Usually the distributor. Okay, but before they entered into an agreement, let's say there was a scenario, there was a script already developed. Okay, let's say script was already developed before entering into an agreement with the distributor. Okay, the producer already had a script before even meeting the distributor. Then if they enter into a service agreement that says, it's work for hire, or it doesn't have to say work for hire. It can say copyright to the film, or copyright to the product developed will belong to company A, right? That provision, a provision like this will create the same legal effect as work for hire. Okay. Now, question. So through that agreement, now there is a script, and they added directing, they added music, they added art, they added acting of the services, and that forms a complete film, right? Now, let's say distributor wants to, and then it says copyright to the product. The whole product developed will belong to the company A, right? Now, let's say company A is the distributor, and whoever had the underlying IP, this is the producer, and this is company B. Now, if a company A now has the copyright to the whole thing, right, under the contract, that's what the contract says. Now, if the distributor wants to make yet another film, like prequel, sequel, or remake, right, can distributor do that without getting permission of the producer? The answer is no. Okay? Because if they're making a prequel or sequel or remake, that will also be based on the script. Okay? Now, when the contract says somebody owns 100% of the results, 100% means 100% that was created under the contract. Okay? Not the underlying IP. Okay? So if a distributor wants to make yet another film, then you will have to pay another royalty for using the script, because the second film will be also based on the underlying IP of the original script. Okay? Question, comment so far? Yes.
What I understood was that distributor, if he wants to make a sequel, he does not need the producer's permission, but still he has to pay royalties for the underlying IP. Is that right?
No. I'm saying that need permission.
Oh.
Yeah. Because if the contract says, when the contract says somebody owns 100%, like distributor owns 100%, what's meant is that 100% of the results that are created after signing of the contract. Okay. If the distributor wants to throw in another provision that says, hey, with the money that we gave you, we'll also own the underlying IP. If the distributor wants to throw in another provision like that, yes, he can do that. But there has to be, that's actually another contract. That's not a service agreement. That's just that's a license agreement, right? There will have to be another license or purchase agreement for underlying IP if the distributor wants to own both the results forward, okay, both the results after signing the contract and the pre-existing work before signing the contract. Yes? Okay. Service agreement, of course, needs quality warranty. Now, why is there no product liability warranty applicable here? Because why is PL warranty not applicable to service agreement? Because there is no product. Product in product liability means things, not services. It's tangible objects that are passed around innocently, okay, without really warning people about their dangers, like cars, right, or guns, okay, or medicines, right. Or chairs, desks. Okay, but in service agreement, there is no such. There is no object that's mass produced and passed around with a look of innocence, right? Passed around with deceiving innocence to the consumers. Okay? When consumers buy things, they think they are getting something safe, right? So the law of product liability is there to protect people's expectation, right? But as to service, there is no mass production of services. Service is given separately to each person. Of course, in the day and age, I mean, in this age of computers and internet, a lot of services are provided by machine over the network by the computers, but still that's a service. Okay. So for instance, Microsoft, lets you write things much more conveniently than you used with your pencils, right? Microsoft does not send the person to type it up for you, but just allows you to do that remotely by sending you some algorithms, right? Some code. But as you are writing, it depending on how you use it, Microsoft Word, Microsoft software can hurt you or may not hurt you. Okay, you may lose your final paper with just one wrong click, right? Like, would you like to save? No. Okay, and you lose the whole paper, right? It's all up to you. It's not wholly up to the service provider. So there is no inequality between manufacturer. There is no inequality between mass producer and consumer that the law needs to address in the service setting. That kind of inequality exists in this manufacturing setting, where the same products are mass produced so widely that people just believe that they are safe and rely on the safety of the products. Okay. All right, that is service. Yes.
Just to clarify, like software, they're not considered as a product. That's one of the most difficult pockets of product liability law. But under product liability law, software, even if it's considered a product because it comes in a CD, it's not. There is no product liability for software. Let's just say that.
What if, like, I was writing using MS Word and there was a fault and just the file, I lost the file not due to my fault.
Yeah. That's why in the end user license agreement, I mean, I'm going to talk about it in the end user license agreement. It says the software is not error free. You are using it at your own risk. Now, yes, I mean, if a product liability law applies, that disclaimer, the product liability law will override that disclaimer and will still hold the manufacturer liable, but that has not been the law so far. As to the software, you are actually getting service, you are actually getting assistance in doing whatever you are doing. You are not getting an object an object that is mass produced, so mass produced as to deceive people into relying on their safety. All right, miscellaneous. Okay, well, any question about service agreement? I mean, maybe I should not have talked about software, but think about lawyer service agreement. No product liability applies to lawyer service agreement. I mean, to the attorney services. Okay. Yes, there will be other laws applicable, like legal malpractice. That's whole other area of law. Okay, that's not product liability. Product liability is a much stronger theory of liability than legal malpractice and stuff. Okay, miscellaneous. There are shorter agreements that I'm going to talk about now that you probably run into much more often than other longer agreements like distributorship agreement and agency agreement. Okay. Repeat after me. Letter of intent. Memorandum of understanding. Heads of agreement. Deal memo. Okay. Are these all different? Or are they all the same? Well, it depends what the substantive terms are. The titles don't matter. Okay. I mean, all these documents are signed in an effort to bind the other side to some level of obligations, but not sign the final agreement. Okay, this is 한국에서 뭐 가계약 부르는 그 목표를 달성하기 위한 여러 방식들인 거죠 지금. 네. MOU, LOI, HOA 다 그런 여러 가지 방식들 중에 하나입니다. But even if the document says LOI, if the provisions are binding, then it's a final agreement. Okay. If a contract says distributorship agreement, but the terms on their surface are not binding, then it can be treated the same as LOI or MOU. Okay? It's not the title that matters. Let's see. What's important is non-binding language. I mean, what usually happens is something like this. LOI says A and B agree to negotiate in good faith along the lines of attachment A or attachment X. And then here is attachment X. That has all the important terms. Okay. Sometimes it might not have the essential, it might not have all the essential terms, okay, but it can have whatever the terms that they can agree upon at the time of signing the signing this LOI or MOU. Now, what's important is that there has to be a language that shows that these terms are not binding. Okay? And if LOI has this sentence, A and B agree to negotiate in good faith along the lines of attachment A, X, that means whatever comes below is not binding. The only obligation that A and B have is what? Negotiate in good faith. Okay. So it's not, the final agreement doesn't have to, if it says 100, the final agreement doesn't have to say 100. Okay. Well, then why do you enter into these LOIs and MOUs? What's the whole purpose? What's the whole purpose? The purpose is to lock in the other party, right? A lot of times LOIs are entered into for a show, just to announce to the world that they are talking to each other. But a lot of times LOIs and MOUs are done in secret, right? Well, if it's done for a show, why they do it secretly? Well, they do it to lock in the other side, to make sure that the other side does not talk to your competitor. Okay? So a lot of MOUs and LOIs, the first provision is the non-binding language. The second provision is exclusivity. Okay? So while this MOU is in effect, you cannot talk to any of my competitor. Okay? So it will say something like either party shall refrain from negotiating with or contacting the other party's competitors, period. Okay? Now, talking to your competitor is not the only way that the other side can harm you. There's another way that the other party can harm you. By releasing the secrets that you have divulged to the other party for the purpose of negotiation. Okay? So for the purpose of negotiation, you may show to the other side things that you didn't show to others. Okay? So for instance, if there is a company that wants to buy your company, your client, then to measure the price correctly, they'll want to look at the company documents that are otherwise secret. Okay? Now, if the other side looks at the documents and send copies to my competitor, right, then my business will be hurt. So usually there is a mini NDA, mini non-disclosure agreement. Okay. So usually an LOI and MOU, when you get it, you have to check 4 things. Does it have non-binding language? Okay. Does it have exclusivity? I mean, not all LOIs need exclusivity, but you should check whether you need exclusivity. And does it have non-disclosure agreements? And most important, does it have the substantive terms that you have some obligation, not final and binding obligation, but you have you have good faith negotiation obligation. Okay? You have obligation to negotiate toward these terms, right? So you need to check whether the contract has those terms that you are obligated to negotiate toward. Okay. So that's LOI, MOU, HOA. And also deal memo is another big title that parties usually use for things like this. End user license agreement. Oh, no, non-disclosure agreement. Okay, well, non-disclosure agreement is what are the terms of a non-disclosure agreement? It goes something like this. You should think of non-disclosure agreement. Think of non-disclosure agreement as a license agreement. Now here, I talked about mini NDA, and mini NDA will just say something like, either party shall not disclose to third party and shall not use for any other purpose usually has two things. Shall not disclose to third party and shall not use for any other purpose what? The information, the confidential information disclosed by the other. Usually this is what mini NDA, well, disclosed by the other for the purpose of this contract. Okay. Now, a full NDA should say something more. Okay. Full NDA should look like a license agreement. Okay. Now, the only special feature of this particular license agreement is usually it doesn't have a royalty. Okay. Now, I said it should be treated as a non-disclosure. It should be treated as a license agreement. If it's treated as a license agreement, what IP are we talking about? What IP is at stake in this particular license agreement? That's supposed to, this particular license agreement that the NDA is supposed to look like. Okay. When I say NDA should be treated as a license agreement, what IP is that license agreement handling? Copyright, patent, trademark? trade secret. Okay, it's trade secret or know-how that that the disclosing party is licensing to the other party, the receiving party. Okay. Usually for no royalty. But when you look at the slide for a license agreement, what's the first thing that you have to do? Well, look at the scope of license. Okay. And in NDA, the scope of license is really narrow. It usually says, hey, it is for inspection purposes only, or testing purposes. Okay. Yes, we'll send you our product, we'll send you our data, but you can use it only for testing. You cannot make money out of it. Okay. That's usually the scope set in the full NDA agreement. Let's see. Any other question about NDA agreement? So just think of it again. Think of it as trade secret license agreement that has no royalty provision attached. Okay. All right. Let's skip end user license agreement, because you will run into that only if you work for IT companies. Okay. But NDA and LOI, that's ubiquitous. Now, boilerplate. Okay, let's do just the important ones. Entire agreement. Okay. If the contract has this provision called entire agreement or integration, that's another term that's used often. It means that all the provisions, okay, all the provisions that they agree to are integrated. What does it mean, integrated? Put into writing. Okay. So this contract is the entire agreement. That's what's meant by the provision titled the entire agreement. Okay. When you look at the sample contracts, you will find them. Okay, and you've already looked at them before, and you probably wondered what that provision does. Well, it does. It shows to the whole world that all the provisions that parties agree to are in that document. But what does it mean? What does it mean? Well, it means that if there is any oral, if there is no written or oral agreement beforehand, okay, previous to the signing of the agreement, then that is void. That is void to the extent that it contradicts this document. Okay. Now, if there is an oral conversation, if there is an oral agreement or written agreement before the signing of the contract, that's not contradicting. Okay, that's not contradicting this document you have, then the previous oral or written agreements are also valid. Valid as something that complement the written contract you have, the final written contract. But if there is no, if the previous verbal or written agreements contradict what's written on the final contract, then they are void. Okay. So that's the role of the provision. So that way, the parties cannot say, after signing, oh, by the way, we had, when we met over coffee, we had agreed to sell you 500, and we just forgot to put it in writing in the final contract. Okay. This provision says, okay, yes, we forgot, so that's void. We'll go by what is in the final contract. Okay, that's the role of the entire agreement provision. Okay. Language. You get this question a lot. You go overseas and sign a contract with a foreign company, and you want to do it. You want to sign in Korean or English so that you understand, but the other side wants to sign it in, say, Arabic. Let's say you are dealing with a Middle Eastern company, right? What do you have to do? Your client wants to sign it in English, and the other side wants to sign it in Arabic. Well, don't fight over it. Okay, you can do it in both languages. Okay. Now, let's say you do it in both languages, so you sign twice, both the Arabic version and English version. Then your client will ask you again, oh, so which one prevails? Now, if there is a provision that says English one prevails, then English one prevails. Okay? If there is a provision that says Arabic one prevails, then Arabic one prevails. What if there is no such provision about which version or which language prevails? Well, then both are equal. Okay? They form one contract. They are not two different contracts. They form one contract, and it's judge's job to somehow weave together the provisions in both contracts, and to create one consistent contract. So don't be afraid of telling your client, yes, sign in both language, and both will be equal, and it will be up to the judge's job to figure out if there is a difference between Arabic one and English one. Okay? All right. Assignment. Again, you will see this provision a lot. And usually it's there to prohibit the other side from assigning the contract. I told you that assignment can be done easily as long as there is no adverse change to the other side, right? So you and I have a contract, and let's say I assign my contract to C. Now, if turning the contract over to C does not cause you any adverse change, then I can freely do it, usually. But you don't want that to happen, right? You want to keep talking to the same party that you signed an agreement with in good faith and trust. Okay? You want to make sure that the contract you signed is not ended up with somebody that you may hate, right? So assignment clause is there, and usually it's a no assignment clause. Okay? There cannot be any assignment.